Hello to all, welcome to the channel. I am Priyanksha and today we will study about intellectual property rights. So let's get started. Let us start with the introduction of intellectual property rights. It refers to the creation of mind such as invention, literary and artistic work, design and symbol, names and images used in commerce. So basically it is any invention or discovery related to any branch which can be used for monetary benefits. So these rights are given to the person who creates those things. So basically, intellectual property rights are the rights given to the person or persons over the creation of their minds. That's why the word intellectual is there. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. IP is protected in law by, for example, patents, copyrights, and trademarks, which enables people to earn recognition or financial benefits from what they invest or create. By striking the right balance between the interest of the innovator and wider public interest, the IP system aims to foster an environment in which creativity and innovation can be flourished. So first we will talk about copyrights. Copyright is a legal term used to describe the right the creator have over their literary and artistic work. Work covered by copyright range from books, music, paintings, sculptures and films to computer programs, database, advertisement and maps and technical drawings or softwares, anything. According to the law, copyright is the right given by the law to creator of literary, dramatic, musical and artistic work and the producer of cinematograph films and sound recordings. So more or less, we all know about copyrights and what are the results of their infringements. Infringement is breaking the law. So here are how the literary work is being protected under copyright law. First, uh, in the case of literary work, except computer program, copyright means the exclusive right to reproduce the work, to issue the copies for the work in public, to perform the work in public, to communicate the work to the public, to make cinematograph, film or sound recording in respect of the work, to make any translation of the work, to make any adaptation of the work. For all these, we need the permission of the creator or the registrar of copyrights. Then comes what is copyright infringement. As I've already told that infringement is breaking of law. Copyright infringement is when the copyright owner's right are violated. Making infringing copies for sale or hire or selling or letting them for hire. Permitting any place for the performance of works in public where such performance constitutes infringement of copyrights. Distributing infringing copies for the purpose of trade or to such an extent so as to affect prejudicially the interest of the owner of copyright. Public exhibition of infringing copies by the way of trade and importation of infringing copies into India. So these are the types how the copyright is being infringed. Now let us understand this copyright infringement with an example. Suppose there is a novel written by person A and person B takes that novel and directs a film. Now that movie or film is being played in a particular theater that belongs to person C. And person C, knowing that the film is basically the story of the novel that is written by person A and not given credits in the whole movie, then also he's showing that movie to the public and earning money, as well as person B is also getting the profits. So in this case, the person A can claim copyright, and person B and C both will be punished under this law. So let's come to the law, that is chapter 11 section 57 of Copyright Act 1957. It says, when a person without a license grant by the owner of the copyright or the registrar of copyrights under this act or in contravention of the condition of a license so granted or any condition imposed by the competent authority under this act does anything the exclusive right to do which is by this act conferred upon the owner of the copyright or permits for the profit any place to be used for the communication of the work to the public, such communication constitutes an infringement of copyright in the work unless he was not aware and had no reasonably ground for believing that such communication to the public would be an infringement of copyright. So here, if the person in our example, if person B and C doesn't know that about the copyright thing, and person C doesn't know that the movies belong to the novel writer, then he would not be punished. Next comes how to prevent such type of infringement. First, you have to register your work and get it copyrighted. A copyright owner takes legal action against the person who infringes the copyright in the work. Copyright owner is entitled to remedies by the way of injunctions, damages, and accounts. The district court concerned has the jurisdiction in civil suit regarding copyright infringements. So these all are under civil law, and civil court will sue the cases. Now let us start with patents. A patent is an exclusive right granted for an invention. Now comes the technical part. Before that, we were talking about copyrights, which is basically about the artistic work. Now we are talking about inventions, scientific inventions. So it provides the patent owner with the right to decide how and whether the invention can be used by others. In exchange for this right, the patent owner make this technical information about the invention publicly available in the published patent document. According to the law, a patent is a statutory right for an invention granted for a limited period of time to the patentee by the government in exchange of full disclosure of his invention for excluding others from making, using, selling, importing the patented product or process for the production of any product for the purpose without his consent. So the patent gives the patentee the right over his invention, that how his invention is going to be used, who is going to be used, and in exchange for that he will give a full disclosure of his invention and the technical details to the government, and government will protect his invention and provide him the right to decide whether his work to be used, sell or import. Now what all inventions comes under this law? An invention relating either to a product or process that is new, involving inventive steps and capable of industrial application can be patented. However, it must not fall into the category of invention that are non-patentable under section 3 and 4, which is we are going to explain in the further slides. The invention to become patentable subject matter must meet the following criteria. What are the criteria? First, it should be novel, it should have inventive steps, or it must be non-obvious. It should be capable of industrial application and obviously not fall under section 3 and 4 of Patent Act 1970. So, section 3 it specifies a few points under which the invention should not come for being patented. So, it should not be frivolous, or it should not be contrary to the well-established natural laws. The primary intended use or commercial exploitation could not contrary to public order or morality, and which causes serious prejudice to human, animal or plant life or health or to the environment. The mere discovery of the scientific principle or formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature, that is already discovered. A mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for known substance, or of the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. Simply already discovered process, already discovered apparatus, machines or their use cannot be a new discovery unless and until they are producing any new product or employs at least one new reactant. After that, a substance obtained by a mere admixture resulting only in the aggregation of the properties of the component thereof, or a process for producing such substance. Then comes arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. Then a method of agriculture or horticulture, any process of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic or other treatment of human beings, or any process for a similar treatment of animals or render them free of disease, or to increase their economic value or that of their product. Simply any medical treatment that could be beneficial for human being cannot be patented to a particular place. After that, plant, animal in whole or a part of their other than microorganisms, but including seeds, varieties and species, and essentially biological processes for the production and propagation of animal and plants. Mathematical or business methods, or a computer program per se or algorithm. A literary, dramatic, musical or artistic work, or other artistic creation whatsoever, including cinematographic work and television products. These all are covered in copyright. So these are not for patent. Then comes any scheme, rule, method of performing mental act or method of playing games. Then presentation of information, topography of integrated circuits, invention which in effect is traditional knowledge, or which is an aggregation or duplication of such properties of traditionally known component or components. All of this cannot be come under patent. Then section 4, that is, no patent shall be granted in respect of any invention relating to atomic energy falling within subsection 1 of section 20 of Atomic Energy Act 1962. which says, as from the commencement of this act, no patent shall be granted for invention which, in the opinion of the central government, are useful for or relate to the production, control, use, or disposal of atomic energy, or the prospecting, mining, extraction, production, physical and chemical treatment, fabrication, enrichment, canning, or use of any prescribed substance or radioactive substance, or ensuring to the safety in atomic energy operations. So all these comes under what cannot be patented. Now, what are the patent protection rules in India? First, it is a textual right only within the territory of India. However, filing an application in India enables the applicant to file a corresponding application for same invention in convention countries within or before expiry of 12 months from filing date in India. Therefore, separate patents should be obtained in each country where the applicant requires protection in his invention in those countries. If you are confused what are convention countries, here it is under chapter 22 of International Arrangements, section 133, convention countries. Any country which is signatory or party or a group of country, union of countries, and intergovernmental organization which are signatory or parties to an international, regional, or bilateral treaty, convention, or arrangement to which India is also a signatory or party, and which affords to applicants of patent in India or to the citizen of India similar privileges as are granted to their own citizen or citizen to their member countries. In respect to grant the patent and production of patent rights shall be convention countries or convention countries for the purpose of this act. This convention countries is a part of World Intellectual Property Organization, that is WIPO. It is a specialized agency of the UN with 193 member of state. Under this Patent Cooperation Treaty, that is PCT, under Paris Convention, assist applications in seeking patent protection internationally for their inventions. That helps patent offices with their patent granting decisions and facilities public access to the wealth of technical information relating to those inventions. So, it is possible to file an international application known as PCT application in India in the patent offices located in Kolkata, Chennai, Mumbai, and Delhi. All these offices act as receiving office, that is RO, for international application. The address of these offices are available on the website of CGPD-TM, that is www.ipindia.nic.in. CGPD-TM stands for Controller General of Patent Design and Trademarks. This is a subordinate office of the Government of India and administrator the Indian law of patent design and trademarks. Now comes trademark. A trademark is a visual symbol which may be a word, signature, name, device, label, numeral, or combination of colors used by one undertaking on goods or services or other articles of commerce to distinguish it from other similar goods and services originating from different undertaking. What are the legal requirements? The selected mark should be capable of being represented graphically, that is on the paper. It should be capable of distinguishing the goods or services of one undertaking from other. It should be used or proposed to be used mark in relation in goods or services for the purpose of indicating or so as to indicate the connection in the course of trade between the goods and services. And some person have the right to use the mark with or without identity of the person, that is with the identity of any organization. Now selecting a mark, if it is a word, it should be easy to speak, spell, or remember. The best trademark are invented words or copied words. Please avoid selection of geographical names. No one can have monopoly right on it. Avoid adopting laudatory words or that describes the quality of the good, that is best, perfect, super, etc. It is advisable to conduct a market survey to ascertain if same or similar mark is used in the market. Under modern business condition, trademark performs four functions. First, it identifies the good or services and its origin. It guarantees its unchanged quality. It advertises the goods and services. It creates the image for the goods and services. Now comes software copyright. It is holding the copyright of software means that you have the protection of the law if anyone tries to steal your software. Under copyright law, the people must not copy the software of other people, lend the software to other people, rent the software to other people, install the software on a network when other user can access it. If someone breaks the copyright, they can be punished by fine or even by imprisonment. Any person who knowingly infringes or abets the infringement of copyright shall be punished with imprisonment for a term which shall not be less than 6 months but which may extend to 3 years. Person can also be fined which shall not be less than 50,000 rupees but which may be extended to 2 lakh rupees. If infringement has not been made for the gain in the business, the court may impose the sentence of imprisonment for a term of less than 6 months or a fine of less than 50,000 rupees. So that's all for now. Thank you so much for listening patiently. We'll meet in the next video. Till then, stay safe, stay updated.